Thank you so much. Keren, I'm sure you also work with a lot of small companies and startups. What advice do you give them on IP? To small startups which are coming to you with less money, uh, but great idea. Uh, what do you do for them?
Yes, I think the first advice would be two. Actually, I have two points to mention. One is that before you decide to draft your patent application, you have to be very knowledgeable about the field of your invention. I generally advise clients to conduct prior art search. They can do it by their own. They can hire a special company that can do that for them, a patent attorney, whichever. But it's highly important to understand the field of the invention, to know, to be very knowledgeable, to understand how you are different from what exists in the market, and try to focus when you draft your first patent application, you have to focus on this difference and explain how you're different, and not only how, and what's this different, what improvement does it provide. These are very important aspects that you have to know, and it's very important to rely on those aspects when you draft a patent application. This is one thing. The other thing is, Ronnie started to mention it, is that you have to be very, very, very careful before you disclose your inventions to others. You should first file a patent application. It can be a provisional patent application. It's much more cheap, so it's mostly you will be able to afford it because patent applications that are not provisional will cost more. So if you have a limited budget, it's preferable to file the provisional. But you should be very careful when you speak with others about your invention. So keeping that in mind, if you feel that you're still your product is still not mature and you want to continue developing it before you file the application, you can do that, but remember to keep silence. And also, if the budget is very limited, I would advise that you file the application just before you start searching for investments, because when you file the application, first application, you have 1 year to file in other jurisdictions. If it's a provisional, you have 1 year before you have to file a PCT application or national applications. And 1 year is very limited time for developing a product. So it would be preferable, if the budget is limited, to file just before you speak with the potential investors.
Excellent, wonderful. Absolutely.
There is another aspect for that, is that if you approach the investors, once you have registered the patent, doesn't matter at what stage your value is higher. So you're in a better place to get invested.
Absolutely.
And also, many clients ask me also if they can just approach and rely on the IND, and I say no, you should also file a provisional application before you approach investors.
Absolutely.
To protect your invention, yes.
True that.